Hello and welcome to our podcast on the protection of intellectual property rights in China. For this episode, we are glad to have Peter joining us. Hello, Peter, and welcome.
Hi, Leonardo. It's my pleasure to be here today and discuss the latest IPR developments with you.
Very good. Today's episode will address the revision of the Chinese trademark law adopted in 2019, focusing on what has changed when registering trademarks in China for European small and medium enterprises.
Very interesting subject. So what are the most important changes included in the new law?
First of all, the new law explicitly prohibits bad faith trademark filings, which is one of the main IP threats for SMEs in China. However, this doesn't mean that such filings will never occur, as bad faith can be difficult to establish. For EU SMEs, registering as soon as possible is still the best option for protecting trademarks.
Is this related to China's first-to-file system?
Exactly. As China uses a first-to-file system, many SMEs are caught out because they fail to register their trademark in China. And then, at the time they want to do business there, they find out that their trademark is already owned by a Chinese company. Very often, these Chinese companies register the mark with the intention of selling it back to the foreign company at an inflated price. And these tactical trademark registrations are commonly called bad faith registrations and are a significant problem that many European companies face in China.
Very interesting. What other measures aiming to protect IPR are included in the new law?
Firstly, anyone is allowed to oppose the registration of a trademark during the 3 months opposition period if they believe that the said trademark is being registered in bad faith. Secondly, anyone may request the Trademark Appeal Board to invalidate a trademark that was registered in bad faith. Furthermore, trademark invalidation requests on the ground of bad faith registrations do not face the 5-year statutory limitation, meaning that anyone can file the request of invalidation even after 5 years from the date of registration. Also, from now on, trademark agencies can be held legally liable for handling bad faith trademark applications. This should further disincentivize bad faith trademark registrations.
This is very useful. And are there any changes regarding the penalties for IPR infringement?
Yes, the new law increased penalties for trademark infringement and allows the trademark owner to request that the goods bearing counterfeited trademark and the material used to manufacture the counterfeited good be destroyed.
This sounds like good news for European SMEs.
Indeed. In addition, the new guidelines for the trial of cases on trademark authorization and affirmation further specify what constitutes a bad faith trademark application, including applications trying to register identical or similar trademarks to those with high distinctiveness. Moreover, the guidelines suggest rejecting trademark registrations for large amount of trademarks without an appropriate reason.
Thank you very much, Leo, for all the information. For more details on China's new trademark law and the main changes to the legal IPR framework, go to www.china-iprhelpdesk.eu and download our trademark guide and many others.
Precisely. You can also send a direct question to our experts via email at question@china-iprhelpdesk.eu.
To be updated about our newest materials and upcoming events, you can follow us on Twitter, LinkedIn, or subscribe to our monthly newsletter.
Thank you for listening and stay tuned for our next episodes.